Good evening, professionals. In the corporate law series, we are in the second series of fundraising, and we have discussed in detail about rights issue, bonus issue, ESOP issue, sweat issue, preferential issue, issue by way of private placement. And today we are going to deal with public issue of shares. Public issue of shares has its own merits and demerits. The pros of public issue are it has efficient access to capital. So company can easily raise funds and you will have greater liquidity, flexibility in trading because your shares are traded in the market, and it is highly transparent. And the cons are greater transparency and disclosure requirements and a lot of corporate governance duties for this company since it is public and it deals with larger stakeholders. Their interests are well protected and add-on compliance cost to the company. So with this brief on the pros and cons of public issue of shares, today we are going to deal with all the detailed prospectus contents, the various types of prospectus, the contents of prospectus, what is construed as prospectus, which is a deemed prospectus when you make an offer for sale to public, and what is shelf prospectus, abridged prospectus, information memorandum, and other type being red herring prospectus. While it has the merits of efficiency to have access to capital, it has a major drawback. You need to be very careful while drafting the prospectus because it has its own liabilities, both civil and criminal liability for any misstatement in the prospectus. And also, it will be construed as a liability and the punishment for fraud under section 447. So meticulously planning and execution is required in the case of public issuance of shares. My sincere thanks to Mr. Sundar for this detailed presentation. These are the various legends used in today's presentation. Most of them are common, which we have been using in other webinars. And this IEPF, Investor Education and Protection Fund, IPO, Initial Public Offer, FPO, Follow-on Public Offer, ISIN, which is International Security Identification Number, or something which we'll be dealing with today. This is the outline for today's presentation. We'll be covering the various types of issuance of shares broadly and what types of issue are permitted by public and private company, again broadly, because we have dealt with this subject in detail in the respective chapters. Coming to our today's session on public issue, issuance of prospectus, the various types, and offer of sale to public by certain members, the deemed prospectus, matters to be stated. What are the contents in prospectus? And what if there is going to be variation in the terms of your prospectus, the contract basically? The public offer of securities shall be in dematerialized form. And what are the rules governing this provision? The advertisement of prospectus and securities to be dealt with in stock exchange. So these securities which will be considered as listed, and what are the regulations which are required to be governed by these companies, and a recent case law on the subject. Broadly, these are the types of issuance of shares: public issue, private placement. While you are not inviting or making the offer in public to purchase or subscribe the securities, and the circulation of offer is intended to specific recipient being investor, then it is a private placement, which we discussed in detail during the last webinar. Rights issue, offer made to existing shareholders. Bonus issue, again in lieu of your profit, you are going to make this bonus issue additional issuance of shares to your shareholders, more as an incentivization. Broadly, these types of issuances are permitted in the case of public companies and private companies, which are private placement, rights issue, bonus issue. Of course, ESOP can also be given by both the companies. However, Private companies are not allowed to issue shares to public. So there is a specific prohibition in the definition section which says that private companies shall not invite or offer members who are public to subscribe for the securities. So only public companies can offer public issue. So the public issue could be in three types. One is initial public offer, which you do for the first time for the public offer. So in the subsequent times when you make such offer after your IPO, it becomes your FPO. Then offer for sale of securities to public by an existing shareholder, which will be construed as a public offer. So all these issuances will be through issue of prospectus, and in simple terms, issue of shares to general public by way of prospectus is termed as public issue. So the relevant terms which we discussed just now: IPO, issue of securities to public for first time; FPO, issue to public for subsequent times by the company after IPO. So here SEBI is the regulator over and above MCA, because in case of listed entities or those companies who have the intention to list on a recognized stock exchange, RSE is recognized stock exchange, the following provisions shall be administered by SEBI. So chapter 3, which deals with prospectus and allotment of securities; chapter 4, which deals with share capital and debentures; and of course your dividend. When you fail to the company fails to distribute dividend, then to protect the interest of investors, SEBI steps into the shoes, and to the extent it relates to A, issuance; B, transfer of securities; C, with regard to non-payment of dividend. In these cases, SEBI is the regulator. In any other case, such provision shall be administered by central government. Yes, over and above this, the contents of prospectus and the filing requirements, everything as per the specific provisions of the Companies Act read with rules shall prevail, and you shall file the relevant forms, and such companies cannot say that I am regulated by SEBI and hence these forms will not apply. What is prospectus? Prospectus is defined under section 2 subsection 70 of Companies Act. It says any document which is described or issued as prospectus. So the title of the document is prospectus. This is an inclusive definition, friends. It says it includes RHP, red herring prospectus or shelf prospectus. We'll be discussing in detail in the respective slides. This next point is very interesting. It says any notice, circular, advertisement or other document which the company makes to invite the public to subscribe or purchase the securities of any body corporate, that will be construed as prospectus. So the last line, professionals, we need to be extremely careful. So any notice issuance which relates to this will be construed as prospectus, and if that does not deal with the respective contents as provided in this section, then it will amount to liability, both civil and criminal. So we have to ensure that the specific provisions are well governed, and the structuring should be in such a way that the such notice is outside the purview of prospectus if it is not intended to be a public offer. Issue of prospectus is mandatory for public issue, yes, and various types of prospectus which could be issued are going to be discussed in the respective slide. Deemed prospectus, shelf prospectus, red herring prospectus, and abridged prospectus. What is deemed prospectus? Section 25 says that when a company allots or agrees to allot any securities, and this is with an intention to offer those securities to the public, such document which is made as an offer for sale to public shall be deemed as a prospectus. So the intention is going to be an offer for sale, and if it is going to be to the public, and two conditions are evident in such allotment of share. One, such OFS, offer for sale, is made within 6 months after you make allotment of shares, or on the date of offer the whole consideration is not received. In both the cases, it will be construed as a prospectus, and hence the relevant provisions, all the matters to be stated in the prospectus as provided under section 26 shall be provided in the document which mentions about this offer for sale to public. over and above that, it shall also talk about the consideration which is going to be received for such offer for sale which is made to the public, and the time and place where such contract is made for the securities to be allotted may be inspected. So these two provisions shall also be added as additional matters over and above what we are going to deal with under section 26 in the next slide. So the persons who make the offer will be named as directors and prospectors. And such offer for sale, if it is made by a company, it shall be signed by 2 directors, this deemed prospectus, and if it is a firm, at least 1/2 of the partners of the firm shall sign. Now, next type of prospectus is shelf prospectus. This prospectus is defined under the explanation provided under section 31, which says in respect of which securities are issued for subscription in one or more issues over a certain period without the issue of further prospectus. So this is going to be like an omnibus provision. So you will have the shelf prospectus done and you are certain that there are going to be further issuances which are going to happen in the near future. So this is more relevant in the case of issuance of debentures, because debentures, companies like NBFCs, banks, they do issue on a regular basis. So they need not issue prospectus every now and then. To avoid such issuance, they will issue a shelf prospectus, and any change to this prospectus will be backed by a document called information memorandum. So any class or class of companies as prescribed by SEBI may file a shelf prospectus. So all companies are not permitted. So those class of companies which are permitted by SEBI may file a shelf prospectus with the registrar at the stage of first offer. And such prospectus is valid for a period of 1 year. So you cannot use the same shelf prospectus during the next sub offers if it is going to be over and above a period of exceeding 1 year. And this is valid till the subsequent offer which is made within that 1 year. And any change between the first offer and the subsequent offer, you shall record it in the information memorandum, and such IM shall be filed in the prescribed form which is passed to within 1 month prior to the issue of this subsequent offer. Where an application for allotment is being received by a company and you are going to make such change after this, then it is the responsibility of the company to intimate all these changes which are recorded in the information memorandum to such applicant. So after reviewing the information memorandum, it is the discretion of the applicant to see whether he would like to invest or not. And if he wants to withdraw such application already made, then the company is obligated to refund all the application monies which were received before such change is effected in the information memorandum. And such refund shall happen within 15 days from the date when the application is withdrawn, and where an information memorandum is filed. This IM together with your SP shelf prospectus will be construed as prospectus. Now, what is red herring prospectus? Section 32. Again, the explanation clearly says that it means a prospectus which does not contain complete particulars. So, you're not sure about the quantum or price of securities, in which case RHP can be issued well before this quantum or price of securities is being determined. And there is a timeline. At least 3 days before the subscription list is open, you may have to file the RHP with registrar, and any variation between your RHP and the prospectus shall be highlighted as variation in the prospectus. And once the offer is closed, all the details of whatever information you had not furnished in the RHP, like your total share capital and the capital which is raised by way of either debt or equity, the closing price of securities as determined, shall be filed with registrar and SEBI. What is abridged prospectus? Abridged, as the name goes, it contains the important key elements or the salient features of the prospectus. So at a glance, if you would like to go through the key terms and conditions before you make an investment, so it is more user friendly for the investor. Instead of going through in detail the prospectus, he might look at the abridged prospectus before making the decision to invest or not in the company. So every form of application for purchase of any of the security shall be accompanied by abridged prospectus. And again, it is an obligation for the company to furnish this to any person who makes a specific request before the subscription list is closed. And if the company makes any default, they shall be liable to a penalty of 50,000 for each such default. Of course, abridged prospectus is not necessary in two cases. When it is in relation to securities which were not offered to public. So when it is rights issue or bonus issue and it is going to be to existing members, then such abridged prospectus is not required. And when it is bona fide invitation which is made to a person who is going to enter into an underwriting agreement. So what is underwriting? It is undertaking the obligation to subscribe for the securities. If such underwriting agreement is entered with respect to such securities, then this abridged prospectus is not necessary to be filed. Offer for sale of shares by certain members of the company. In consultation with board, if certain members propose to offer either their entire holding or part of their holding, such document which invites or makes an offer for sale to the public will be deemed to be a prospectus. All the obligations, all the contents of the prospectus will apply as provided in 26 for this case as well. The liability, the civil criminal will also hold good to this document, and members who make such proposal, they shall collectively authorize the company to make such issuance on their behalf, and they shall reimburse the expenditure incurred by the company with respect to such offer. The deemed prospectus shall disclose the name of the persons who make such proposal along with the cost of making the offer for sale and the reasons. So the chapter 3, prospectus and allotment of securities provision shall apply in this case also when there is an offer for sale made to the public when consultation with the board. However, there are certain exceptions. The minimum subscription, minimum application value, and statement to be made by the board with regard to utilization of money, and detailed justification if any other provision is not being complied with. All these provisions are not applicable in the case of offer for sale being made to public by certain members. What are the contents in prospectus? Section 26 provides the detailed list together with the rule. Every prospectus shall be dated and signed, and it shall state such information and also the report on financial information as may be specified by SEBI in consultation with central government. And until the date SEBI provides such information to be set out on the financial matters, the regulations made by SEBI along with your SEBI Act 1992 shall prevail. Most importantly, this prospectus shall contain a declaration stating that the company has complied with all the provisions of the Act, the Companies Act, SEBI Act, SCRA, Securities Contract Regulation Act, read with the relevant rules and regulations made thereunder. Like any other offer, this prospectus is not required to be issued when it is going to be issued to existing members, or when issue relates to shares or debentures uniform, which is ditto the existing shares or debentures which are previously issued and dealt with in your recognized stock exchange. The date indicated in prospectus shall be deemed to be the date of publication, and the prospectus shall be signed by every person who is named therein as a director or proposed director, or by his duly authorized attorney. Such prospectus shall be filed with the registrar, and it shall be indicated on bold letter stating that such prospectus has been filed with the registrar, and it shall also state the fact that a copy has been filed, and the documents attached to it shall also be mentioned either in the prospectus, or it shall refer to the statement in the prospectus which provides for such documents filed along with your prospectus, the respective form. And the prospectus shall be valid to be issued within a period of 90 days from the date on which the same has been filed with registrar. This is very important. When the prospectus is issued, it shall not include a statement purporting to be made by an expert unless the expert is a person who is engaged in the promotion, formation or management of the company. and the company has obtained express consent in writing from such person, stating that his name is being mentioned as an expert to this particular statement, and he has not withdrawn his consent before filing the copy of the prospectus with the registrar. So all these conditions have to be satisfied to include a statement quoting that such statement is purported to be made by an expert. And if any company contravenes the provisions, it shall be liable with a fine from 50,000 to 3 lakhs. And for every person who is responsible for such issuance of prospectus, he shall be punishable with a fine, which shall be again the same 50 to 3 lakh, or imprisonment up to a period of 3 years, or with both. What if there is variation in the terms as stated in your prospectus? Then the company shall not vary unless a special resolution is passed, and where the company has any unutilized amount of money raised, in which case it shall not vary the terms of contract unless special resolution is passed through a postal ballot. So section 27 read with rule 7 of chapter 3 of company's prospectus and allotment of securities defines the procedural aspects. So it contains the matters to be stated in your special resolution. These are the matters: the purpose or object of the issue, the money raised, utilization of money, the extent of the proposed object which is achieved. So you would have stated for what object you have raised this money, and 50% or 60% if you have achieved, you shall state that in your notice of resolution. Unutilized money shall be mentioned, and what are the details of the terms of contract which are modified now, and the reasons or rationale behind such variation, and proposed time limit within which the proposed varied objects would be achieved, risk factors, and such other relevant information which will be relevant for the members to take an informed decision. And this notice shall also be published in newspapers, both in English and vernacular, and such notice shall be filed in Pass 1, the form prescribed by MCA, and the company shall not utilize such amount raised for the purpose of buying or trading or dealing in any equity shares of any other listed company, and the shareholders who have not agreed for such variation, the company shall provide an exit offer along with such other manner the terms and conditions with exit price as prescribed by SEBI. Now, section 29 deals with public offer of securities in demat form. So all companies shall issue securities only in demat form by complying with the provisions of your Depositories Act read with regulations. When such company is making public offer or such other class of companies as may be prescribed. However, such class of companies are yet to be prescribed, and the promoters of every company making a public offer may hold such securities only in demat form. So it is mandatory that the promoters hold such securities in demat form. This also includes convertible securities. So then you should not wait until the, say for example, CCPS are issued and it is going to be converted after a period of say 10 years into equity shares. They cannot make an excuse stating that CCPS will be converted only after a period of 10 years. So immediately that should also be converted in and held in demat form. This is an insertion, very important, professionals, as far as unlimited companies are concerned. So previously you had such provision for listed companies and such other class of companies as may be prescribed, but now unlisted companies are also required to hold the securities in demat form, without which you will not be able to transfer any security, and without which you will not be able to subscribe for any additional security, be it a rights issue or bonus issue. So it's very important that all the companies make this security available in demat form and comply with Rule 9A. So Rule 9 governs the provisions of public offer of securities in demat form, and Rule 9A talks about every unlisted company to issue the securities in demat form and facilitate demat of all the existing shareholders and make information to all these shareholders stating that the securities shall be made available in demat form in accordance with the provisions of Depositories Act 1996 read with regulations. So various amendments are made in the company's prospectus rules by third amendment effective 10 September 2018, and the recent one also inserting this past 6 form to be filed for reconciliation of share capital, which was issued wide notification on 22nd May 2019. So all these recent amendments have to be kindly considered and noted for compliance. So every unlisted company making any offer or buyback of securities shall ensure that before making such offer, entire securities held by the promoters, directors or KMPs shall be dematerialized. So this is effective 2nd October 2018. And every company, as mentioned earlier, shall facilitate demat of all its existing securities and secure this ISIN number. And every unlisted public company shall ensure that the following formalities are complied with. 1. Make necessary timely payment of fees, whether it is annual fee or custodial fee to your RTA, the registrar and transfer agent, share transfer agent, or to the depositories, and maintain the security deposit at all times. So which shall be at least 2 years and comply with all the other regulations as prescribed by SEBI and depository. These companies shall file Form Pass 6 within 60 days from the conclusion of half year. So it starts effective this month. So for the 30th September, all the unlisted companies shall do this Pass 6 filing on or before 30th November unless extension is provided by MCA. And the company shall immediately bring to the notice of depositories of any difference between the issued capital and the capital held in demat form. The grievances can be notified to IEPF authority, Investor Education and Protection Fund, and IEPF shall initiate any action after prior consultation with SEBI. Exemption is granted for compliance of Rule 9A to Nidhi company, government company and wholly owned subsidiary company. So advertisement of prospectus shall be published with the specified matters, the contents of memorandum with regard to objects, liability and the capital structure, the name of signatories to the memorandum and the number of shares subscribed by them and the capital structure of the company. So allotment of shares, very, very important. So shares allotted to public shall not be allotted unless the minimum subscription has been received. So the minimum subscription amount is the key criterion for allotment. Unless that amount is achieved, you will not be able to allot shares. So minimum subscription shall be, the quantum is prescribed, at least 5% of the nominal amount or such other percentage as may be specified by SEBI. And if minimum subscription is not received within 30 days from the date of issuance of prospectus or such other period as may be granted by SEBI, then the total money shall be refunded within 15 days from the date of closure of the issue. And if such money is not refunded, then the company, the directors who are officers in default shall jointly and severally be liable to repay with interest at the rate of 15%. And we all know that allotment shall be filed in Pass 3. And previously it was 30 days, now it is changed to 15 days. And the company and officer in default, the contravening provision is fine of ₹1,000 for each day of continuing default or 1 lakh, whichever is lower. And all these securities to be dealt with in stock exchanges are dealt with under section 40. Every company making such public offer shall make an application to one or more regional recognized stock exchanges and obtain permission for the securities to be dealt with. So you may have to file the listing application, and once the listing approval, originally they will give in principle approval, and after complying with the necessary conditions, the final listing approval, and then comes the trading approval, post which only the securities can be traded. Where a prospectus states an application as stated above has been made, such prospectus shall state the name of the stock exchanges in which the securities are proposed to be dealt with, and all monies received on application shall be kept in a separate bank account. And very important, professionals, it shall not be utilized other than for adjustment for allotment or repayment. Just like your pref issue, it shall be kept in a separate bank account and it shall not be utilized until it is allotted or could be refunded back. And any condition purporting to require or bind any applicant to waive compliance will be construed as void. So a company cannot initiate any action requesting to waive compliance to this provision, and a company may, however, pay commission in connection with subscription to securities subject to such conditions as may be prescribed, and the payment of commission is dealt with in the specific Rule 13 we will be dealing with in the next slide. The contravening provisions are: company is liable for a fine from 5 lakhs to 50 lakhs, huge penalty. Every officer in default, he shall be liable to a fine ranging from 50,000 to 3 lakhs or imprisonment maximum of 1 year or with both. So company is allowed to make payment of commission. However, the following conditions shall be satisfied as provided in Rule 13. So it shall be authorized by Articles of Association and it may be paid out of proceeds of issue or profit of the company or both, and it shall not exceed 5% of the issue price or rate authorized by articles, whichever is lower. And in the case of debentures, it is 2.5% or as permitted by articles, whichever is lower. Copy of contract shall be filed with registrar with regard to the payment of commission. It shall not be paid to any underwriter on securities which are not offered to public. So prospectus shall also disclose the name of the underwriters, rate and amount of commission, and the amount, number of securities to be underwritten. Any questions, friends? Any clarification on the subject? Please feel free to ask. Finally, we have an interesting case law on the subject. So we read in the previous slide that if the minimum subscription money is not received by the company, then it is statutory obligation for the company to refund the money back. So there cannot be any excuse to adherence to the provision of section 39, and the company, if they are not refunding the money back, they cannot make an excuse stating that the necessary fund, if there is some litigation or due to impending litigation with the bank, they have not refunded the money back. So the obligation is without any compromise, and this is what is held in this judgment by SEBI. The petitioner company, APL Industries, had not received minimum subscription amount as stated in prospectus. SEBI had advised this company to refund the application money so receipt, and this was also seconded by High Court. And the petitioner company had written letters to respondent banks requesting them to refund all monies to the applicants along with accrued interest. But there was a dispute because the bank clarified that they have not earned any interest on the application money and stated that the company and directors would be jointly and severally liable, and the bank in this case, being the respondent, will not be accountable for making the interest payment. So the petitioner company wrote a letter to SEBI stating that the legal action had been initiated against the respondent bank for making such payment. However, the High Court, Delhi High Court, held that the impending legal proceedings could be there with the respondent bank. However, it is the obligation of the company to ensure that the necessary amount is made available and the refund warrants are issued to the applicants, and they cannot have an excuse stating that the respondent bank, there is some legal proceeding which is happening, post which the amount will be settled. So the amount has to be settled within the time frame as indicated in the provisions. So thank you very much, friends. With this, we conclude the session on public issue of shares. Next session, we will be dealing with public issue of debentures.